Now comes part two, and we'll deal with the fourth issue. District Court ignored 18 U.S.C. 927 West Virginia statutes as West Virginia law did not classify my temporary commitment as probative. Petitioner's unlawful commitment was temporary. West Virginia Code 27-5-2AG specifically states such commitment, if lawful, does not prohibit firearms ownership for temporary commitment unless duly notified by the committing judge. See West Virginia Code 61-7-7A4. West Virginia Code 61-7A-3 maintains a state mental health registry for those prohibited to be reported to the National Background Check System in compliance with legislative intent expressed in West Virginia Code 61-7A1 to include those prohibited by 18 U.S.C. 922G4. Petitioner was prohibited from testifying about his knowledge of state law, and his attorney was verbally warned about his addressing it to the court. See attachment 5, page 74 at line 10 to line 19. Judge Berger actively prevented the petitioner from addressing his own legal argument to preserve violations on record under 18 U.S.C. 927 at sentencing. See attachment 6, page 36 at line 13 to line 18. Attachment 5, page 73, line 3 to line 4. Court states, nor was Mr. Bumgard allowed to go around it. See attachment 2, page 10, line 5 to line 16, where David Bumgard addresses violations of West Virginia Code as put forth by the petitioner in the habeas corpus. And page 11, line 17 to line 20, where the court makes a statement that petitioner's address of violations should have been addressed in state court and the appropriate objections made and preserved and all those things. You know, like the habeas corpus. The court admits the commitment was unconstitutionally applied to the petitioner at page 11, line 19 to line 20, where David Bumgard states reference as his applied challenge being similar to a habeas argument and is cut short by the court at line 21 to line 23, all present at the appearance of deliberate conspiracy and abuse of powers. Argument for issue 4. I'm just going to leave this out here like this. Let you take a good old look at everything nice and slow. Now, that gets us to our final argument. I'm just going to leave it on this before we go any further. See, everything that's cited, for the most part, except for a few things in the final argument, like the letters of Judge Berger, are all unsealed evidence. And unsealed evidence can be shown publicly with no concern for how it is viewed by the public because it's unsealed. It's public record. I can't go to jail for revealing public record. And as you can see, it's unsigned. There's a list of attachments. West Virginia habeas corpus. June 5th motions hearing. Different items of those. Attachment 3, which is the trial transcript at different areas, different items. Attachment 4, the ATF report. I can't show you this. It was sealed as part of the letters that I sent to Judge Berger. But there's the number for the document, which you can double check with my docket sheet. 5, transcript, trial transcript, volume 1. Of course, I cite everything here that was said. A few explanations. They're not exact quotes unless they're quoted and in italic. But you see this throughout other areas as well. And all this reveals everything you need to know. Here's the list of citations. 20 of them total. all of them a mix of state and federal law. I have a high definition camera, so you'll be able to see everything. See, there's something none of y'all really get, especially you, Don. You've been fighting with me all day today. It's my birthday, so you give me a present. But guess what? That is just attention to one more thing that you don't want attention brought to. I'm going to go chase a page down. And that, my friend, is that I plagued you in each and every way throughout all of this. I'm using you, manipulating you. You're calling this about a fight, but this is about me proving that you lied about my criminal history. And in so doing, prove that you're a liar. And don't worry, that'll be up on YouTube too. Bye now.